Good morning and welcome to the first webinar in our two-part series discussing significant construction and adjudication cases of 2025. These webinars aim to cover key developments in construction and adjudication practice and how these might affect your construction disputes in 2026. Our webinar today is going to focus on our chosen top 5 construction cases of 2025. We will highlight the main facts and legal points arising from each and will identify some key takeaways from the decisions. It is important to note in the time we have available, we will only be providing you with an overview of the points we think are most relevant. However, please be aware that there may be other important points coming out of these matters that we don't cover today. The webinars are going to be recorded, so they will be available on our YouTube channel. If you want to listen again or pass on to colleagues to catch up, then please feel free to do that. Before we begin, just so everyone's aware, we've put everyone on mute just to minimise any background noise, but if you do want to ask any questions, there is a Q&A webinar chat function. In order to keep to the 30 minutes, we will just answer as many questions as we can at the end rather than as we go along. If we don't get to your question, or if you're listening to a recording of this webinar, we'll be happy to address any queries after the webinar by phone or email, and our contact details are on the next slide. So I'm Hayley Russell, a senior solicitor in the Property and Infrastructure Disputes team at Shepherd and Wedderburn, specialising in construction and engineering disputes. I'm joined by my colleague Gemma Nimmo, who is another senior solicitor in my team. Our team regularly advises on construction contract issues and disputes across a wide range of projects and industries. Our work spans numerous sectors, which can include energy, transport, education, hospitality, leisure, and commercial real estate. We have experience in litigation both in the Court of Session and the Sheriff Court, and in all forms of alternative dispute resolution, so that includes adjudication, arbitration, and mediation. As construction dispute specialists, we have an up-to-date understanding of the legislative, court, and industrial context of disputes, but we also have a strong commercial focus, and we advise clients on the various standard form contracts on a regular basis. So that variety of practice means we've got quite good experience with a lot of different disputes. I'm now just going to pass over to Gemma, who is going to run through the agenda for today's webinar.
Thanks, Hayley. In this webinar, we're going to focus on the 5 cases that were decided in 2025, which have important consequences for the construction industry. The cases that we will highlight today fall into 3 broad categories, which are the Building Safety Act 2022, prescription periods and time bar, and payment in construction contracts. 2025 saw 2 key cases that impacted the interpretation and implementation of the Building Safety Act. As the construction industry continues to deal with the aftermath of Grenfell and the subsequent commitment to addressing cladding safety, it's no surprise that this year saw 2 important Building Safety Act decisions. URS Corporation against BDW Trading Limited strengthened the rights of developers to recover remedial costs under the Building Safety Act. Additionally, the requirement of developers to contribute to cladding repairs and remediation, despite the availability of public funding, was confirmed in Triathlon Homes LLP against Stratford Village Development Partnership and others. Our second topic, the operation of prescription periods and time bar in a construction context, received judicial attention this year. The time at which the prescriptive period for defects claims commences was clarified in Greater Glasgow Health Board against Multiplex Construction Europe Limited and others. Also, Legal in General against Halliday Fraser Monroe confirmed that defences, including time bar, contained in the main contract are not automatically incorporated into a related collateral warranty. Key developments in relation to payment and construction contracts occurred this year. It has been confirmed in Place First Construction Limited against CAR Construction North East Limited that a payment notice and pay less notice were both valid despite being sent at the same time. We have produced articles on the majority of these cases, and those can be found on the Shepherd and Wedderburn website. If you would like to read about the cases after the webinar, the articles can be accessed from the knowledge section of our website. So I'll move on now to discussing the case of URS Corporation against BDW Trading Limited. This case saw the rights of developers being strengthened in relation to the ability to recover remedial costs. The background to this case is as follows. BDW Trading Limited, which I'll refer to as BDW, conducted investigations in the aftermath of the Grenfell fire and found serious cladding issues in 2 high-rise residential developments. BDW carried out the remedial works despite no longer having a proprietary interest in the building. BDW brought a common law negligence claim against the structural engineer allegedly responsible for the defects, URS Corporation Limited. Prior to the enactment of the Building Safety Act, the action would have been time-barred. However, Section 135 came into force retrospectively extending the limitation period for accrued claims from 6 years to 30 years. BDW proceeded with the action and URS resisted liability in the proceedings on several grounds. The Supreme Court granted permission to appeal and the decision focused on 4 grounds, which each we'll discuss individually. So ground 1, the first ground concerned whether BDW suffered actionable damage or if the damage was outside the scope of the duty of care. URS argued that BDW's losses were not recoverable because the remedial works were carried out without legal obligation on a voluntary basis, also citing the fact that BDW had no proprietary interest. The Supreme Court rejected this, finding that BDW had suffered actionable and recoverable damage, and there was no general legal principle that bars recovery based on voluntariness. Ground 2, the second ground was whether Section 135 of the Building Safety Act applied in circumstances, and if so, to what effect. The court confirmed that the extended limitation period under the Building Safety Act applies to both claims made under the Defective Premises Act 1972 and to related negligence and contribution claims. The court acknowledged that this reinforces the underlying purpose of the Building Safety Act, ensuring that those responsible for building safety defects can be held accountable and that proactive developers are not left without recourse. Ground 3, the third ground is whether URS owed a duty to BDW under the Defective Premises Act and, if so, whether BDW's alleged losses were recoverable under the duty of care. The court widened the scope of the Defective Premises Act, clarifying that developers can benefit from a duty of care despite having no proprietary interest in the building. It was also confirmed that economic loss, including costs incurred in repairing defective works, are recoverable. This clarification will likely see a rise in claims under the Defective Premises Act due to the widening of its scope. Ground 4, the fourth and final ground, was whether BDW were entitled to bring a claim against URS under the Contribution Act. BDW were permitted to seek a payment contribution from other parties, such as a consultant or contractor, without a prior judgment, settlement or third-party claim if it had incurred compensatory losses. So the practical implications of this decision are that the judgment represents a significant strengthening of developers' rights in relation to building defects. It signals the courts are committed to upholding the purposes of the Building Safety Act. Given the new 30-year limitation period, we may see actors in the industry being exposed to historic claims with significant costs attached.
Thanks, Gemma. We're now going to look at the case of Triathlon Homes LLP versus Stratford Village Development Partnership and others. So this is a Court of Appeal decision which followed a decision of the First Tier Tribunal. The Tribunal's decision concerned 5 apartment blocks that were constructed as part of the London 2012 Olympic Village. The buildings were subsequently converted for use as private housing, but an investigation revealed significant fire safety defects in relation to both the design and construction of the external cladding. The total costs of the remedial works are estimated to be around £25 million. Triathlon Homes sought a remediation contribution order under Section 124 of the Building Safety Act from the original building developer Stratford Village. Triathlon was seeking its share of the remediation costs, which were around £16 million. The developer disputed the claim on 2 grounds. So the first being it was not just and equitable to grant the remediation contribution order, and the second being that the order should not extend to costs that were incurred prior to the introduction of Section 124 of the Building Safety Act coming into force, which came into force on the 20th of June 2022. The tribunal rejected the developer's arguments and granted the remediation contribution order. So this decision was then appealed to the Court of Appeal, which had to determine whether it was just and equitable to grant the remediation contribution order and whether the orders can be interpreted as having retrospective effect. With regards to whether it was just and equitable, the developer's primary objection was that the order being granted was not fair or reasonable because public funds were already being made available from the Building Safety Fund to cover remediation costs, and the court found that public funding did not displace the provision of the Building Safety Act requiring a contribution from the developer, because the purpose of the legislation is ensuring building safety remedial works are completed and to resolve who pays for that. The court agreed that using public funds should be seen as a last resort, and that the availability of public funding would not be a reason not to make an order, as the primary responsibility for paying for those costs should fall to the developer. Furthermore, the funding agreement in place required that the applicant used reasonable endeavours to pursue claims, so that could include applying for a remediation contribution order. There was obviously a public interest in the fund being reimbursed to prevent unnecessary depletion of it. So the requirements of the developer to pay were upheld, and granting the order was deemed by the court as just and equitable. The court also rejected the argument that the remediation contribution orders cannot be retrospective in nature, and the retrospectivity was deemed necessary to comply with the underlying purposes of the Building Safety Act, and the court was satisfied that the potential unfairness of this approach was limited by the requirement for an order only to be made where it is just and equitable. So the key implications of this case is that the Building Safety Fund does not displace a developer's obligations to cover remediation costs. It is therefore just and equitable for remediation cost orders to be made against a building developer, even if public funding has been made available for the remedial works. Additionally, developers and landlords can be held liable through this remediation contribution order for costs incurred prior to June 2022 in respect of building safety defects.
Thanks, Hayley. I'll now come on to talk about Greater Glasgow Health Board against Multiplex Construction Europe Limited and others. In this case, the Scottish courts provided much needed clarity as to when the 5-year prescription period for construction defect claims begins. So the background to this case, the dispute concerned the construction of the Queen Elizabeth University Hospital in Glasgow. The date of practical completion was 26th of January 2015, and on 22nd of January 2020, a Court of Session summons was served on Multiplex regarding alleged defects relating to the atrium cladding. Multiplex defended the action by primarily arguing that the claim had prescribed, i.e. it had passed the time limit for raising the claim. The prescription argument had the potential to be a knockout blow to the action, as if a claim has prescribed, it cannot be litigated on. In assessing Multiplex's argument, the court considered 3 broad points. The first was when prescription began, the second was the induced error test, and the third was reasonable diligence. So coming on to the first point of when prescription began, the Health Board argued that prescription began at the point of practical completion. Multiplex offered the alternative argument that prescription began in January 2013, as this was the first point that the Health Board first paid for the defective cladding. The court confirmed prescription began at the point of practical completion. This isn't a novel clarification, but it was welcomed by the industry nonetheless. The second part was the induced error test. So additionally, the Health Board sought to rely on the saving provisions in the Prescription Act. These provisions could extend the prescription period if it was proven that Multiplex induced the Health Board into error regarding the defects. The court was not satisfied on this argument, noting that none of the witnesses gave evidence that supported inducement. The court drew the distinction between being ignorant as to the state of affairs and being induced into error. Additionally, Multiplex's undisclosed knowledge of the atrium defects did not itself amount to inducement. And on the reasonable diligence point, the court deemed that the Health Board's failure to comply with its internal fire safety policy was a failure to exercise reasonable diligence. The key takeaways in summary from this case are that the court has reaffirmed the well-established position that prescription begins at practical completion. The decision also strictly limits when the saving provisions in the Prescription Act can cure a time-barred claim. The decision acts as a stark reminder that accurate, up-to-date project records and early issue spotting are the best safeguards against parties potentially losing the right to recover for defects.
Thanks, Gemma. So the next decision we will look at is Legal & General versus Halliday, Fraser, Monroe. This is a Scottish case in the Court of Session, primarily dealing with contractual interpretation of collateral warranties, as well as the prescriptive periods that then apply to collateral warranties. So the background of this case, it concerned Union Plaza, which is a multi-storey office building in Aberdeen. Legal & General purchased the building in December 2013, and the building achieved practical completion in July 2018, which Legal & General were then the second buyer of the building. In January 2014, Legal & General entered into a collateral warranty with Halliday Fraser Munro, and they were the architect firm. So it is this collateral warranty that became the focus of the judgment. So the purpose of a collateral warranty in this scenario would be to give comfort to the ultimate purchasers that they benefit from the same contractual and legal duties that the builder, architect, or engineer owed to the original employer or client who hired them to design and build the premises. And the collateral warranty provided that in purchasing the block, Legal & General were relying on the architect's firm's skill and judgment in relation to the provision of architectural services as per the terms of Halliday Fraser Munro's original appointment, and that the architect firm had warranted to Legal & General that it had used all reasonable skill and care in providing those services. The collateral warranty also stated that the architect firm did not owe Legal & General any greater duties or obligations than they had owed to the original employer. So Legal & General basically went on to discover multiple defects to the building, and that included defects in the design, application and monitoring of the protective paint system used on the building, as well as discovering issues in relation to defective soffit insulation. So Legal & General raised court proceedings against the architect firm in December 2018 in relation to the defects. The basis of its claim was that Halliday Fraser Munro had breached the duty and obligations to exercise reasonable skill and care, as we said, as was agreed in the collateral warranty. And Halliday Fraser Munro argued that Legal & General's claims were out of time, and that was based on the 5-year prescriptive period that is allowed under the Prescription and Limitations Scotland Act. So Halliday Fraser Munro argued that the purpose of a collateral warranty was to provide both equivalent rights and defences that were contained in the original contract. So they said that that allowed them to rely on the same prescriptive period that had applied to their original appointment, which meant that any obligation to pay damages to Legal & General had prescribed, because prescription is 5 years. So the court had to consider whether the collateral warranty had the same prescriptive period as would have been the case under the original contract. And the court found that the purpose of a collateral warranty is, as I sort of suggested, to give subsequent purchasers a direct contract, so if problems arise, they would have a means of redress. So by entering into this collateral warranty, Halliday Fraser Munro promised to carry out work to a proper standard. And the court found that the defects discovered were a breach of contract regardless of the timing of the collateral warranty. And that is partly to do with contractual interpretation, but also because there were no terms in the collateral warranty restricting the time limit for enforcing rights and obligations to the same time limit allowed under the original contract. So there were clauses that said the firm owed no greater duty to Legal & General than the original employer, but the court interpreted that clause to relate only to the scope of obligations rather than to apply to the prescriptive period. And the court provided crucial clarification by holding that a collateral warranty is a standalone contract, which means a new prescriptive period was triggered from the date it was signed. The collateral warranty was dated 6th of January 2014, so the duties were enforceable within 5 years from that date, rather than practical completion of the premises. This means that the claim brought was valid as it was brought within the 5-year period. I think this case is a crucial reminder just for those involved in the design and construction process that collateral warranties can stand alone. So unless express wording is used, not to automatically assume that it will incorporate the same prescriptive periods for making a claim that exists under the original contract. Without specific wording, prescription will just run from the date the warranty is signed rather than practical completion. And it also should not be assumed, as was in this case, that clauses relating to not owing a greater duty would limit the duration of liability, because as we've seen here, those would likely be interpreted only to limit the scope of obligations.
Thanks, Hayley. We'll now come on to Place First Construction Limited against CAR Construction North East Limited. So in this case, the court provided clarity on the validity of payment notices and pay less notices. So Place First Construction Limited, who I will refer to as Place First, were the contractor on a construction project who engaged CAR Construction North East Limited, who I will call CAR, as a subcontractor on the project. During the project, CAR emailed its interim payment application to Place First. Place First responded with an email containing 2 attachments, a letter claiming to be a pay less notice, and an Excel workbook described as Valuation 30. The second tab in the workbook was headed Subcontract Payment Certificate, which Place First contended performed the function of a payment notice. Both parties disagreed as to their payment liability, which led to adjudication proceedings. In October 2024, the adjudicator decided in favour of CAR and ordered Place First to pay £867,031.06 plus VAT. The adjudicator decided that Place First had failed to validly serve either a payment notice or a pay less notice. Both parties applied to the Technology and Construction Court, and CAR sought to enforce the adjudicator's decision, and Place First sought a final decision on the dispute. So on the validity of the pay less notice, CAR argued that the pay less notice issued was invalid as it was served in advance of the permitted date. CAR's case was that the pay less notice preceded the issuing of a notice determining the notified sum. The court held that a notified sum could validly be provided in a payee's application for payment. The judge clarified that there was no logical reason to require a payer to first issue a payment notice and then follow that up with a pay less notice. So as such, Place First's pay less notice was held to be effective. Coming on to the validity of the payment notice, the court acknowledged that one notice cannot operate as both a payment notice and a pay less notice, despite the content of each being precisely the same. It was held the workbook issued by Place First, entitled Subcontract Payment Certificate, was intended to have separate effect from the pay less notice and therefore amounted to a payment notice. As such, Place First had validly issued a payment notice. The key implications of this decision is that the Construction Act does not require a payment notice and a pay less notice to both be issued for either to be valid. The reasoning for this is because the content of a payment notice and pay less notice can be identical. This case is also a reminder that one document cannot serve as both a payment notice and a pay less notice.
Okay, thank you. So we actually, in very record time, have reached the end of our presentation today. So we've obviously whittled through that. So we definitely have some time to answer a couple of questions. If you haven't already done so, please feel free to type any questions you might have in the Q&A box now, and I'll just give a few minutes for you to do that. Okay, there actually is one question in the chat, and that is there anything coming up in relation to payment we should be thinking about for 2026? That's a good question, but it's obviously quite broad. So one thing though that is worth putting on your radar, the UK government recently completed a consultation on 8 proposed payment reforms, and those are aimed at tackling poor payment practices, which obviously, as we probably all know, is a really recognised challenge in the construction sector, although it is aimed across like all UK businesses. But particularly with construction, obviously, we've got tight margins, problems with cash flow that can cause stress to businesses. So if the reforms are all enacted, it will be the most significant reform to payment practices in the industry in over 25 years. And one of the proposed reforms in particular, I think worth drawing your attention to that caught my eye, was in relation to retention. So with retentions, the government actually intends to either prohibit retentions entirely or to introduce requirements in relation to how they operate, and I believe those requirements are quite stringent. Now, both those options are actually considered viable by the government. So if enacted, I do think this could be challenging for smaller businesses because they might not be in a position to provide bonds or guarantees as security. And the government is expected to publish the outcome, or if they don't have an outcome yet, a reason as to why not and when an outcome will likely come out. And that's actually mid-January. So that should be coming pretty soon. So that's one to look out for. And I've been checking and nothing's out as of yet, but keep your eye on that one.
Yeah, I think we've got another question in the Q&A box, Hayley, which is in relation to the case concerning one notice being a payment notice and pay less notice at the same time. Am I right in thinking there was another similar case this year? Yes, so the case from today said it can't be both a payment notice and a pay less notice. But there was also a case between Vision Construct and Gypcraft Drylining, where parties tried to argue that a payment notice could be retrospectively recharacterised as a pay less notice, which the court refused. So that kind of hammers home the point that it's important to be really careful when it comes to dealing with payment and to strictly comply with the payment provisions that are in the contract.
Yeah, and there's actually linked to that, Gemma, a question in the chat box, another one that says, with regards to payment notice, pay less notice, you mentioned a single document can act as both. Does that mean any deductions made on a payment notice needs to be followed up with a separate document titled pay less notice to be valid? Yes, is the short answer to that. So yes, you do need to have a separate pay less notice to a payment notice, so you can't have it in the one document. And that is sort of the case we looked at today as well, that Gemma just mentioned too. It definitely needs to be a separate document. Okay. All right. I think that's actually all we have time for today. If I've not got through your question, we can come back to you by email. So I just want to thank you all very much for attending today. The next webinar is on the 27th of January. So if you wish to sign up, please do so by visiting the news and events section of our website. We have also got a link on our site that will take you to that to sign up. If you'd like to provide any feedback on the webinar, including suggested topics for future, at the end of the series, there will be a survey that you can feedback on. So please feel free to complete that. We hope the webinar has been useful and we look forward to welcoming you all back. Thanks again, everyone. Thank you.
Thank you.